Hello, everybody, and welcome back to the show. We are joined by attorney Bobby Harges, a professor of law at Loyola University and an attorney with years of experience in mediation. He's here today to talk with us about child custody law.
Whether you're going through this process for the first time or already have a custody arrangement in place and you're trying to have it altered, Bobby Harges is here to take your questions. So, Bobby, why don't you give us an overview of child custody? What are the main things that you want to talk about this morning?
John, I'm here today to discuss the approaches in Orleans Parish, Jefferson Parish, and St. Tammany that the courts use to process child custody cases. As you know, child custody cases are high conflict. The parties are very emotional, and many times they can't deal with each other. So the courts are developing programs to assist the litigants to work through their issues and to determine what's in the best interest of the child.
Yeah, and you're very big on mediation. That's what we're talking about, right? Mediation.
That's correct. Mediation is a process where a neutral person who is trained in resolving disputes, that person has a background in the law or in mental health, and that person sits down in an office and works with the litigants to resolve their disputes.
And so whatever they decide is binding for both parties.
If they enter into a contract and it's entered as a consent decree in the court, it is binding, and that they would have to live by that agreement.
So let me see if we can kind of put this in a general framework. Whenever there's a dispute about child custody, the courts, if it gets in front of the judge, is interested in what's in the best interest of the child.
Correct. Mediators
are an effective tool, you advocate, to help the parties come together and maybe work out an arrangement without ever having to get in front of the judge.
Correct. And the mediators also use the best interests of the child. Those factors that are used by the courts are used by the mediators, and they work with the mother and the father or the parents, and they talk about and discuss what's the best interest, and the agreements are reached with that in mind.
And so let's just, both of you, I'd like to ask you this because it could be expensive. It could be very expensive and very challenging. And we were talking beforehand, a lot of times people try to do this by themselves. What do you say to that?
The statistics, why don't you tell the statistics that your research has shown?
Well, many litigants in this metropolitan area are going to court without lawyers, either because they cannot afford lawyers or they wish not to have lawyers. In Orleans Parish, I've heard statistics that 75% of litigants in family court do not have lawyers.
Wait, 75%?
75%
do not have lawyers.
They're maneuvering through the court system by themselves without the assistance of lawyers. And in Jefferson Parish and St. Tammany, the numbers approach 50%.
Wow.
So you're looking at least half of the litigants in our viewing area that do not have attorneys.
Yeah.
Just to add to that and to underscore it, I can tell you as someone who has practiced some domestic law early on in my practice over 20 years ago, but still familiar with it because I interact with these lawyers, it's so expensive. And if you don't have a very high-paying job, when you go see a domestic lawyer and you say, I want to fight for child custody, I want to change custody, they want thousands of dollars. As a retainer. Happy to help you, but pay me thousands of dollars. And that has got to be the #1 reason why people say, I can't pay that, but I'm still going to show up at the courthouse.
Right.
And mediation is one of these tools that even lawyers agree will save lawyer fees, but even without a lawyer, you're not left all by yourself. Mediators are neutral.
They are neutral. They are trained in dispute resolution techniques. They have history primarily in family issues, and they work with the parents to highlight what is in the best interest of the child. So the factors that are used by the court, they are used by the mediators.
Yeah.
And couples come to an agreement most of the time. I think the national rate is about 80% of litigants who go to mediation.
That's great.
Correct. They resolve at the mediation and they move on with their lives as opposed to fighting over and over and time again.
So if I'm someone out there who's watching this and this sounds really interesting, sounds like it could really help me and be very beneficial, I look for a mediator. Is that what I look for?
Look for a mediator. You can go on the internet in the yellow pages and put in family mediator or domestic mediator, and you can find that person. Find that person's bio on the internet, screen that person, and you can have someone who can help you with the other spouse or the other parent to resolve disputes without the significant cost associated with litigation.
Are there some, oh, go ahead.
Well,
sorry.
just to add to that, there are plenty of mediators out there. In fact, MAPS is a company that mediates lawsuits over car accidents and medical malpractice. But a family law mediator, that's a certification that you want to require, and courts that work with mediators require that certification. Is that correct?
That's correct. In order to be a qualified family mediator, you have to have a license as an attorney, psychiatrist, psychologist, social worker, or mental health professional, and you obtain 40 hours of training in mediation techniques. And you discuss things like execution of agreements, child custody, visitation, domestic violence. All of those things are discussed. So the mediator comes to the mediation process with that knowledge and with the best interest of the child standard, and that person works with the parents to help them to resolve their disputes.
And so what if I already have a custody agreement, but I want to alter it in some way? Could I still go through the mediation process? Would that still be available to me?
The first choice would be to try to work it out with the other parent. If that doesn't work, you can simply call a mediator, and that person will work with the parties and then get another custody agreement. It could be filed with the court, or if they don't wish to file it, they could just act under the agreement themselves.
Let me add to that too. The thing about mediation, the very good thing about mediation is nothing happens in mediation unless both parties actually agree. In fact, I think currently in Orleans, Jefferson, and St. Tammany, mediations are recommended, but they're not required. Is that true?
That's correct.
The trick is to get the other spouse to agree to come with you to see a neutral party. And you know, some spouses, there's a lot of emotional stuff. They don't want to have anything to do with that other spouse, and that's I'll see you in court kind of business.
Right.
If you can convince that person to say, look, let's go see this neutral party. You can spend thousands of dollars on your lawyer. I can spend thousands of dollars on my lawyer. That's our kids' future college money or school tuition money. Let's go to a mediator. Ask your lawyer if your lawyer thinks it's a good idea. And I bet your lawyer should agree. It's
Bobby,
a good idea. Let's try and work it out.
You're shaking your head. You totally agree with him, right?
I've seen recent statistics that the average litigated divorce in this country is about $40,000.
Wow.
With each parent paying about $20,000. The average mediated divorce is more or less hundreds. I've seen stats from $1,000 to $2,500 for the average cost for both parties combined being $1,000 to $2,500 versus $40,000. Now the cost in Louisiana may be a bit less. So you're looking at hundreds of dollars for a mediator versus thousands of dollars for a litigated divorce.
And so is everything the same parish by parish? Does it all remain the same, or are there some differences?
There are some differences in procedures. We all operate under the same laws, but the procedures are different. For example, in St. Tammany Parish, the court uses, in addition to the judges who resolve the disputes, hearing officers who are experienced lawyers who sit as court employees, and they resolve most of the custody and visitation disputes. They also have licensed social workers who act as parenting coordinators and mediators, and they are staff mediators. In addition, St. Tammany uses private mediators who mediate in their offices. The court can order those cases to mediation. Jefferson Parish has 4 hearing officers that process the domestic cases, along with 2 domestic commissioners. Orleans Parish is exploring the possibility of using private mediators to help it process custody and visitation cases. So currently in Orleans Parish, there are 3 judges with a family docket, and they process all the cases, and they are exploring the use of mediation because it's so popular and litigants like it, it's cheaper, and it works.
And it works. Now we've been talking, or we made the assumption that these couples are married, but there are a lot of couples out there who are not married who have these same issues, and I would imagine that might make things a little bit more difficult, correct?
Absolutely. In fact, the nutshell is the law still stays the same. What is in the best interest of the child? If neither party, if they weren't married when the child was born, and they go their separate ways, they're both unmarried. If one wants to go live with somebody else, some judges might say, well, that's an unhealthy environment, or some judges may say, in today's age, it doesn't matter. The law is silent about that. The law doesn't say that it should not be a bar in general. If it's a healthy, loving environment, one would think, and I would argue if I were counsel, it doesn't make any difference. A healthy, loving environment is a healthy, loving environment. But I don't know if Bobby has any other.
John, it should make a difference. When you look at the factors for the best interest of the child, they discuss things like the relationship between the child and the parent, the stable environment, the ability to provide financially, the ability to educate. Those are factors that are used by the courts. The fact that someone is unmarried or of a different race or of a different gender as far as sexual preference, those factors should not be considered. But we can't say that a judge may not consider them, but by law they should not be considering those factors.
Okay, great conversation, and we're going to continue the conversation, but when we get back, your questions, we already have some great ones, so stay tuned. We'll be right back in just a moment.